Okay, everyone, today I want to talk about the Bill of Rights and all of the different principles that the Bill of Rights embodies. And as we will see, the true test of the Bill of Rights is going to be a Supreme Court case ruling. And so when we look at the First Amendment, it definitely is bulky, as I've mentioned before, and there are certain principles that make up the First Amendment. And the purpose of the First Amendment is that it guaranteed that Congress could not make laws that establish a state-supported religion, prohibit the free exercise of a person's religion, abridge freedom of speech, abridge freedom of the press, respect the right to peacefully assemble, or respect the right to petition the government. And so the First Amendment guarantees that individuals will be protected. In other words, they can do all of these things and Congress cannot stop them. However, as we will see, the Supreme Court can make rulings that can definitely limit each of these activities. So pertinent cases related to the First Amendment, we're going to divide this up by different categories because, again, the First Amendment covers so much. So in terms of the Establishment Clause, this is the part of the First Amendment that guarantees that the government will not establish a national religion. And the two most relevant cases are Engel versus Vitale and Lemon versus Kurtzman. In Engel versus Vitale, the court ruled that prayers in school is unconstitutional. And in Lemon versus Kurtzman, the state cannot provide aid to parochial schools or religiously affiliated private schools. And they established a three-pronged test to determine whether the Establishment Clause had been violated. And so this would set a precedent for future cases. And so the three-pronged test included that the purpose of the legislation must be secular, not religious. The primary effect of the legislation must neither advance nor inhibit religion, and the legislation must avoid an excessive entanglement of government with religion. And when we look at free exercise and what this actually looks like, there are two cases that are significant, and both of them dealt with issues regarding people believing that their protection from the government infringing upon their free exercise was the same as free belief. And so what happened in Reynolds versus the United States is that Utah had made a law making polygamy illegal, and Reynolds, who was a Mormon, was a polygamist, and he was arrested and convicted for violating the law. Reynolds challenged the law based on the Free Exercise Clause, and the Supreme Court ruled that the law was constitutional and that the practice of polygamy was not a violation of the Free Exercise Clause. So essentially, if a religion is going to deem some act to be part of their religious practice, it cannot violate an existing federal or state statute. And so keeping in that same line, in Employment Division of Oregon versus Smith, it dealt with the practice of Native American Indians of using peyote as part of their religious ritual. And Oregon refused to grant unemployment benefits because the Native Americans used illegal drugs and were dismissed from drug counseling jobs. The Supreme Court upheld Oregon's decision, stating that there was a compelling governmental interest in regulating drugs. So even though peyote was part of their religion at that time, or it still is, peyote was illegal, and so that did not give them a free pass. Other parts of the First Amendment, when we look at the principles of freedom of speech, we have a whole bunch of topics. Just a little bit more about the principles. So the issue of free speech revolves around the extent and limits the government can place on free expression. Speech is classified as expressive and symbolic. Individuals can bring up lawsuits called slander against entities that use speech to defame one's character. Speech can also be limited during times of war if it can be proved that the speech limits the government's ability to conduct its war policies. Speech can be limited if it is obscene or if the speech creates a threat to an individual or a group. And the Supreme Court has ruled that the First Amendment applies to the states through selective incorporation. So Gitlow versus New York established what would become known as the clear and present danger test. At the time, it was called the dangerous tendency test. And essentially, a man's arrest and conviction was upheld by the court because he was passing out pamphlets trying to get people to join basically the Socialist Party, and he had violated the New York State anti-anarchy law. And so the Supreme Court said that because what he was doing was creating dangerous tendency, it could not be protected. In Chaplinsky versus New Hampshire, Chaplinsky called a city official a damn fascist in a public place, and he was arrested for violating a breach of the peace. And the Supreme Court upheld his conviction, and in its ruling established the fighting words doctrine. Words that can inflict injury or cause a breach of the peace can be regulated. All right, moving on to Schenck versus the United States. This was a case where, again, Schenck was passing out paraphernalia, urging people to speak out against the war and oppose the draft. And the United States accused him of violating the Espionage Act, which makes insubordination and draft resistance illegal. Were his actions a violation of the First Amendment right to free expression and free speech? The Supreme Court ruled that it was not and upheld his conviction. And Justice Holmes equated his actions to yelling fire in a darkened movie theater, and the court ruled that he had created a clear and present danger by advocating his position. So we see that part of the ruling in Schenck was based off of the precedent established in Gitlow. And the doctrine of the clear and present danger test gives the government the right to prosecute individuals who, through expressive or symbolic speech, create a clear and present danger. All right, looking at something we all can relate to. What rights do students have in terms of speech on campus? And as you might imagine at our school, not many, but what about in our public schools? Well, a couple of students decided during the Vietnam War that they were going to wear black armbands as a silent protest against the Vietnam War. They were suspended, and they sued the school district, and the court ruled that the suspension was unjustified and that the black armband represented symbolic speech that was protected under the First Amendment. The court stated that the students' rights, quote, do not stop at the schoolhouse gates, end quote, but also recognized that the schools had the right to intervene if there was a material and substantial disruption of the school environment. And obviously that last part is going to be left up to the discretion of the school to determine what is considered material and substantial. And this would become the first in a number of cases that raise issues of whether students attending public schools were in fact protected by the Bill of Rights just as they are as regular citizens outside of school campuses. And lastly here with free speech, Texas versus Johnson. Flag burning is protected by expressive speech, although it's very controversial. Some might argue anti-American, anti-patriotic. It is protected under expressive speech. And in terms of free press principles, one of the most significant cases was the New York Times Corporation versus the United States. And the issue was that some of the Pentagon papers or information regarding a secret study the Pentagon had done of the Vietnam War, some of that information was published by the New York Times and the Washington Post. And President Richard Nixon obtained an injunction against both papers that forced them to stop publication of the material. And Nixon claimed that the release of the Pentagon papers would hurt national security during the Vietnam War. And so the issue became, did the publication of the Pentagon papers, was it in fact protected by the First Amendment's Free Press Clause? And the court ruled that the New York Times and the Washington Post did have the right to publish the papers, and that the government had actually misused its authority of prior restraint when it asked the courts to censor the publications. So prior restraint is the formal definition of the government censoring material, and the press and individuals are protected from prior restraint, meaning that the government is not at will allowed to prevent the publication of certain materials. And we'll finish up here with assembly and petition of grievances. And this is another important part, last part of the First Amendment. And essentially it establishes the right of people to gather in places and express their points of view without government interference, the right of people to freely associate with groups they choose, and the right to petition government officials for policies that they want. And I don't have too many exciting or any Supreme Court cases for you, but if you think about the Westboro Baptist Church, which is the group that assembles at the funerals of deceased soldiers, that would be an example of a group exercising this right, albeit very unconstitutional, albeit very distasteful very horrific, very hateful, it is actually protected, sadly enough.